as you might be well aware, in the recent past there has been a brewing controversy pitting the Office of the Director of Public Prosecution as against that of the Ethics and Anti-Corruption Commission. Well, while we acknowledge of this controversy, it is important that we highlight on behalf of the members of the public what really is the position of the law as far as this controversy is concerned. Now, just yesterday of course we were entertained to a news item where officers of the Ethics and Anti-Corruption Commission made an assertion that they will be keen on persuading the legislators, these are the MPs, members of the parliament, to come up with a law that will be permitting or will permit the Ethics and Anti-Corruption Commission, upon the conclusion of the investigations, to prosecute suspects or individuals who will be suspected of having committed crimes against the laws of this country as far as the anti-corruption offenses are concerned. Now, it is important that even while we appreciate the intentions of the Ethics and Anti-Corruption Commission, that we look at this argument from a constitutional perspective. Sheria Mtaani and Shadrack, Wambui, who are representatives of the vulnerable, the very vulnerable in the society, it is important that we interrogate very keenly and thoroughly, at least from a historical perspective, what we have today as the Office of the Director of Public Prosecution separate from the Office of the Investigators, which are either the DCI and the Ethics and Anti-Corruption Commission. Well, I know my senior, Mr. Dunstan Omari, will take us through the historical perspective of why we find these two offices separated, why we find the office of the AG and that of the DPP separated. It is important that I analyze, or at least on behalf of the public, why we have thought it very important that as Sheria Mtaani and Shadrack, Wambui, we take action. We take action in anticipation of the anticipated legislation from the members of parliament. Because the problems that we face as a country, the challenges that we experience as a country, flow from the lawmakers, action or inaction. And from the invitation, as you will have read from today's Nation newspaper, is that there is a deliberate, the People's Daily, there is a deliberate attempt by the EACC, working in cahoots or in committee with the members of parliament, to come up with a law that withdraws the power of the Director of Public Prosecutions and gives this power to prosecute to the Ethics and Anti-Corruption Commission. Well, it is important that we highlight that the separation of these two offices and the delimitation of their functions as far as the Constitution is concerned is deliberate. It's a deliberate act that was done by the framers of the Constitution so that the vulnerable members of the public are not subjected to a system where the investigator becomes also the prosecutor. And this is for very obvious reasons. Because the investigator has a lens through which he looks at the alleged offenses having been committed or alleged to have been committed by the suspect. While the Director of Public Prosecution, who is under a constitutional duty, not only to prosecute offenders, but also to look at what the public interest is concerned as far as the prosecution of the suspect is concerned when a file is presented before them. So as members of Sheria Mtaani and Shadrack, Wambui, we are keen and we shall be moving to the High Court for the purpose of seeking an interpretation as to whether it is constitutionally sound for the members of parliament to enact a law that withdraws the power of the Director of Public Prosecutions and grants this power to prosecute to the Ethics and Anti-Corruption Commission. I note that our history is replete with so many examples. You will recall that not so long ago, when we had a similar controversy, a power play between the former Directorate of Criminal Investigation, Mr. Kinoti, as against the then Director of the Director of Public Prosecutions, Mr. Mohammed Haji. In the year 2020, particularly at around the month of April, a petition was filed by one gentleman by the name of Geoffrey Sang, Geoffrey Sang then was the acting CEO of Water Harvesting and Storage Authority. This is a parastatal formed under the Water Act. And you will recall that during the exchange, the power play, the director of criminal investigations, the director of public prosecution, sorry, Mr. Haji declined an incessant pressure from the office of the director of criminal investigations to prosecute Mr. Geoffrey Sang, leading to an action being taken solely by the office of the Directorate of Criminal Investigation, Mr. Kinoti, to filing or preferring charges as against Mr. Geoffrey Sang. Now, Geoffrey Sang, feeling aggrieved, filed a constitutional petition before my Lord Justice George Vincent Odunga, now currently a judge sitting at the Court of Appeal. And this decision, made by Judge George Vincent Odunga, then seated in Machakos Law Courts, was of one historical importance. My Lord Justice G.V. Odunga decreed and made a determination on this question and observed that even while the Directorate of Criminal Investigations was keen on nipping to the bud, perpetrators or criminal offenses, it was constitutionally unsound for the Directorate of Criminal Investigation as an investigator to have filed a complaint and to have taken up the action of prosecuting Mr. Geoffrey Sang. Because the court was of the view that the office of the Directorate of Criminal Investigations, which is an investigator, akin to the office of the Ethics and Anti-Corruption Commission, will not be permitted by the Constitution to commence or rather to prosecute suspects of any criminal act that was deemed under the laws of Kenya. So for that reason, that decision made by Justice George Vincent Odunga becomes relevant even now to at least play in the mind of the legislators who are being invited by the Ethics and Anti-Corruption Commission to come up with a law withdrawing the powers of the DPP and bestowing those powers to the office of the EACC. So it is important that the common man understands that even with these fights going on, these fights are actually to the benefit of the members of the public. They are to the benefit of the vulnerable in our society. Because if in any event we have a situation where the EACC will be keen on abusing their power by prosecuting someone, as we have seen in a number of occasions where we have stopped the EACC, where they have sought orders, obtained orders illegally after failing to disclose material information before courts, and then they have used those orders to seek the prosecution of the alleged suspects. So for us to prevent a situation where there is an abuse of the prosecutorial powers, it is important that the investigators stick to their lane, while the prosecutors also stick to their lane. And this is so deliberate so that we allow a system where every public officer is audited by the other. We have a system of checks and balances that prevents the overflow of power or of course, the abuse of power or office that we have always seen from public officers who fall under the temptation of abusing power that has been given to them. So without saying much, I will rest at that, pave the floor to my colleague, Mr. Stanley Kinyanjui, to also dive a little deeper into this question about separation of powers and why we should not allow, why we should never countenance a situation where the office of the investigating officers in the name of EACC are allowed to enjoy the powers and the privileges given to the office of the ODPP. That should be all from me. Thank you.